Excellencies, distinguished guests, ladies and gentlemen, I am very pleased and honored to welcome you all to this one-day conference by which we are celebrating the 20th anniversary of the adoption of the UNIDROIT Convention on stolen or illegally exported cultural objects. We are very appreciative of the willingness of the Italian Ministry of Heritage and Cultural Activities to open and support this conference, and to the municipality of Rome to host it. The speakers and participants gathered here today are drawn from both the legal and practical sides of this question. I was not president of UNIDROIT when the convention was negotiated and adopted, but I know that several persons who did participate in this adventure are here today, and they bear witness to the obstacles that had to be overcome and to the need to reach an agreement on the recovery of stolen or illegally exported cultural objects. A warm welcome to you all. Let me also take this opportunity to welcome in particular the Assistant Director General for Culture of UNESCO, Mr. Perez de Amignan, and to thank UNESCO for the constant and strong support given to UNIDROIT and its 1995 convention since the very beginning. The 1995 convention is the result of our extremely fruitful cooperation and is, of course, complementary to the UNESCO 1970 convention. The fight against illicit trafficking of cultural objects is not only a priority or a mere political commitment. It is also a collective responsibility. Illicit trafficking of cultural property is a scourge that is constantly expanding and taking on new forms. The civilized world can no longer tolerate this despoilment. The civilized world cannot remain indifferent to these offenses. The civilized world cannot allow important artistic and cultural testimony to our roots, the roots of humanity, of the whole world, steadily to be destroyed and fragmented. The 20th anniversary of the 1995 Convention provides an opportunity to assess the significance, the distinctive features and operational aspects of this normative instrument and its interaction with others, including the 1970 UNESCO Convention and the 2014 European Directive on the return of cultural objects unlawfully removed from the territory of a member state. It is important in this context to acknowledge that essential rules are already in place and that focus is now required in ensuring that they are better known and applied. On behalf of UNIDROIT, I would like to thank you for having come to Rome to bring your invaluable contribution and bearing witness to the great interest generated by this initiative. Thank you. Thank you, and I now give the floor to Mrs. Giovanna Marinelli, who's here representing the Minister Franceschini, who unfortunately could not attend. Mrs. Marinelli, you have the floor.
Buongiorno, benvenuti. Io sono qui per darvi il benvenuto a nome del Sindaco che con suo grande rammarico per un impegno precedente non può essere con noi. La città di Roma è veramente molto contenta di poter festeggiare il 20° anniversario della Convenzione che ha consentito di intervenire in maniera molto determinata sul traffico delle opere d'arte, obbligando, come sappiamo, gli acquirenti a verificare la legittimità, la provenienza delle opere stesse. Diciamo che è proprio, come voi tutti sapete, dal Campidoglio, esattamente da questo palazzo naturalmente, che nel 1995 è cominciato tutto. Il 24 giugno esattamente, quando è stato firmato il trattato che non è stato soltanto una linea di indirizzo importante per combattere il fenomeno del furto dei beni culturali, ma soprattutto lo ha fatto puntando su una omogeneità transnazionale e sulla condivisione di norme che favorissero veramente lo scambio e la restituzione delle opere trafugate. L'Italia e Roma in particolare sono state molto spesso negli anni vittime di tutto questo. Basta pensare ai molti danni che ha subito Villa Doria Pamphili, che era un vero e proprio museo all'aria aperta e che purtroppo ha visto trafugare e mutilare molto del suo patrimonio che in grandissima parte poi non è stato possibile ricostituire. Questa Convenzione ci ha consentito di portare a casa risultati importanti, anche se è indispensabile non abbassare la guardia. Dall'antiquarium dei musei capitolini nel 2012, quindi molto poco tempo fa, c'è stato un ultimo furto che per fortuna si trattava di una tabellina funeraria che per fortuna è stata recuperata in brevissimo tempo, e tutto questo lo dobbiamo anche all'impegno del Comando dei Carabinieri per la tutela del patrimonio culturale, che si è fortemente impegnato in tutti questi anni, e tra il 2013 e il 2014 abbiamo registrato un calo quasi del 10% e una percentuale che faceva anche seguito al meno 24% dell'anno precedente. Dunque diciamo che abbiamo risultati veramente confortanti, che sono dovuti naturalmente all'impegno che è stato sottoscritto appunto 20 anni fa. Io voglio ricordare in questa occasione il contributo che a tutto questo è stato dato da un assessore che mi ha preceduto, ed è Gianni Borgna. Gianni Borgna ha ricordato in un suo libro esattamente un episodio importante che fu il furto di 5 quadri di Annibale Carracci e del Guercino, tra gli altri, che avvenne proprio nel momento in cui lui era assessore e che furono tempestivamente recuperati dal generale Conforti, che allora guidava naturalmente il gruppo dei Carabinieri per la tutela del patrimonio culturale. Lo ricordo non solo per l'impegno che lui ha profuso per questa città, ma proprio per sottolineare come da parte di questa amministrazione c'è stata sempre una collaborazione e un'attenzione costante e soprattutto una preoccupazione costante, che è un dovere per una città che ha un patrimonio delle dimensioni che sappiamo e che ha un'esigenza assoluta non solo di tutela e di conservazione, ma anche di difesa, per così dire, rispetto ai possibili furti. Io ci tengo quindi a sottolineare che questo incontro per il Comune di Roma non è soltanto un anniversario e per così dire una celebrazione, ma è il rinnovo di un impegno, ed è soprattutto l'occasione per ringraziare tutti, dagli organizzatori del convegno naturalmente a tutti i presenti, che hanno voluto assicurare attenzione a temi così importanti. Grazie.
Thank you, Ms. Marinelli, and I apologize for making a mistake in your presentation. I thought that you were going to be speaking in replacement of the minister, but my mistake. I again apologize. Je donne maintenant la parole à l'ambassadeur Nassir Fiti, qui est chef de mission de la Ligue arabe en Italie. Vous avez la parole.
Merci bien, Monsieur le Président. Mr. President, Excellencies, ladies and gentlemen, allow me first to convey to you the best wishes of the Secretary General of the League of Arab States, Dr. Nabil Al-Arabi, for the 20th anniversary of the Convention on Stolen or Illegally Exported Cultural Objects, as well as for a successful conference today. Dr. Al-Arabi apologizes for not being able to participate personally due to official commitments at this moment. I remain confident that the issues addressed, as well as the many approaches used, as we will see today, but the importance is that these issues are addressed in a comprehensive, interrelated way, bringing different experiences and also reflecting on old and new challenges. Adding to that, the participation of eminent distinguished specialists will enrich this dialogue who have their expertise, of course, but also their experience in the field. That's much needed in order to develop the philosophy of this convention, to develop also new ideas and policy initiatives on strengthening the main tenets, principles, as well as goals of this convention. This is what we really expect, and I'm sure we're looking forward to see happening at the end of the day. As a former long-time representative of the Arab League to UNESCO, I speak in front of my good friend here, I know very well, and sometimes you're frustrated, the importance, the challenges, and the much needed commitment of the international community to the goals of this convention. Cultural property remains a main aspect. It's a main aspect of different civilizations and national culture. It's a key element in our universal civilization. Indeed, protecting cultural heritage and promoting different forms of cultural exchange definitely will greatly contribute to the promotion of understanding between different societies and to the respect, much needed respect, of diversity. This will also contribute to enriching this exchange and, again, the much needed understanding and harmony among different cultures and civilizations. I am sure that our conference today will bring greatly added value to the goals of this convention, which we all share. Thank you, and wishing your conference all success.
Thank you, Ambassador Hitti. I now give the floor to Mrs. Maria Vittoria Marini Clarelli, who will speak on behalf of the Ministry of the Italian Ministry of Heritage and Cultural Activities, who could not be present, as I mentioned at the beginning. You have the floor, Mrs. Marini Clarelli.
Thank you, Mr. President, Excellencies, distinguished member of the UNIDROIT Council, speakers, ladies and gentlemen. I'm very honored to be here. Let me begin by conveying the greetings of the Minister of Culture and Tourism, Dario Franceschini, who cannot be with us today, as he would have wished. He asked me to replace him because I was a member of the Italian delegation to the diplomatic conference that adopted the draft of the UNIDROIT Convention on stolen or illegally exported cultural objects here in Rome 20 years ago. The conference was hosted by the Ministry of Culture in the Complesso di San Michele a Ripa and lasted 3 weeks, during which the suspense was high until the very last moment. And the work often continued informally during the night in the magnificent Villa Aldobrandini, UNIDROIT headquarters in Via Panisperna. Everybody knows that the UNIDROIT Convention on stolen or illegally exported cultural objects was signed in Rome, and that this is the reason why the government of Italy is its depository. But I wonder whether all of you know that the signature ceremony took place in this very building, designed by Michelangelo Buonarroti, although in another gallery of the museum in the Sala degli Orazzi e Curiazi. Therefore, the stages of the last and successful phases of that long and difficult negotiation were 3 wonderful Roman historic palaces. Perhaps to demonstrate the truth of the motto adopted by the diplomatic conference, Ars Grata Legis. Many speakers today shall explain the importance of the UNIDROIT Convention under the legal and political point of view, also in comparison with other international instruments. I would like to recall at least 3 important innovations introduced by this text that started to be influential in its essential lines before becoming an official document. First, it provides that bona fide acquirers of stolen or illegally exported cultural objects who have exercised due diligence but who are required to return the objects are entitled to compensation upon their return. Second, it limits the cases in which a buyer can claim to have exercised due diligence, Third, the Convention set out a limited right of return for illegally exported objects. Moreover, I wish to underline that the 1995 UNIDROIT Convention contributed to change the mentality and attitudes of people towards cultural heritage, including professionals often hostile to the concept of restitution, such as many art museum directors. In many respects, the practical effects of the 1995 UNIDROIT Convention are less relevant than its social and cultural impact, in spite of, or perhaps also because of, the negative reaction that the Convention initially provoked in the art market. The restitution and return of illegally removed cultural objects can now be possible even without starting a legal action. It happened, and perhaps it could have not happened before. Therefore, in some way, we can consider the UNIDROIT Convention itself as a cultural object, even if it is less than 50 years old. We celebrate today its 20th birthday, and it is also a way to react to the recent ruthless destruction of some irreplaceable monuments that is casting a shadow on the destiny of our cultural patrimony. Thank you for your attention.
Thank you, Mrs. Marini Clarelli. I now give the floor to Mr. Alfredo Perez de Armignan, Assistant Director General for Culture at UNESCO. You have the floor.
Merci, Monsieur le Président. Monsieur le Président, Excellences, Mesdames, Messieurs. Monsieur le Président, Monsieur le Secrétaire Général, mon cher ami José Angelo Estrella Faria, permettez-moi tout d'abord de vous remercier au nom de la Directrice Générale de l'UNESCO, Madame Irina Volkova, que je représente, et à mon nom propre, de m'avoir convié à cet important événement que nous célébrons. Dans cette merveilleuse salle Pietro da Cortona des musées Capitolini, grâce à l'hospitalité généreuse de la commune de Rome. C'est avec une sincère émotion que je souhaite aujourd'hui rendre hommage au personnel et aux experts d'UNIDROIT et à ceux qui en particulier mettent en œuvre la Convention sur les biens culturels volés ou illicitument exportés dont nous commémorons ensemble le 20e anniversaire, ayant été signée ici même au Capitole Hill, au lieu de la culture mondiale, le 24 juin 1995. Cette convention occupe une place bien particulière, a été déjà soulignée par les orateurs précédents, dans l'action de l'UNESCO en matière de lutte contre le trafic illicite des biens culturels et des restitutions. Dès sa création en 1995, elle est apparue comme un complément essentiel de la Convention de l'UNESCO de 1970, concernant les mesures à prendre pour interdire et empêcher l'importation, l'exportation et le transfert des propriétés illicites des biens culturels, dont nous vous parlerons dans quelques instants. Et depuis lors, la Convention de 1995 est progressivement passée du rang de petite sœur à celui de bras opérationnel du traité de l'UNESCO. C'est tout particulièrement sur la délicate question des retours et restitutions des biens culturels volés ou illicitement exportés que la Convention d'UNIDROIT complète très utilement la Convention de 1970. Son approche originale, visant à l'harmonisation des droits privés nationaux, repose ici sur un compromis entre les intérêts de la libre circulation des biens et ceux de la protection du patrimoine culturel irremplaçable. Le subtil équilibre juridique ainsi ménagé par la Convention de 1995 vous sera exposé en détail dans la suite des discussions, mais je souhaite à ce stade souligner l'unicité de cet instrument juridique en droit international. Aucun traité n'offre à ses États membres une telle protection en cas de vol ou d'exportation illicite d'objets culturels, notamment contre l'argument de la bonne foi de l'acquéreur ou d'une diligence supposée convenablement exercée. Il s'agit, dans les circonstances dramatiques que nous connaissons aujourd'hui au Moyen-Orient, de deux points cruciaux que tous les États doivent très sérieusement considérer. Pour ces raisons, le secrétariat de la Convention de 1970 travaille depuis plus de 20 ans en très étroite collaboration avec ses collègues d'UNIDROIT, qui se voient associés à tous les ateliers de formation organisés par l'UNESCO autour des thématiques de lutte contre le trafic illicite et de restitution des biens culturels. Nous saisissons d'ailleurs toutes les occasions que nous sont données pour convaincre les États qui n'auraient pas encore adopté la Convention de 1995 de le faire sans tarder. Ce n'est en effet que largement ratifié que cet instrument pourra déployer sa pleine efficacité et que les États pourront en connaître tous les effets bénéfiques. La Convention UNIDROIT, en effet, n'échappe pas au principe de non-rétroactivité qui régit le droit. En principe. Dès lors, pour que cette disposition puisse être appliquée, la Convention doit être déjà entrée en vigueur dans les 2 États partis à la procédure. Ainsi, plus les États retardent leur ratification, plus ils perdent leur capacité à protéger leur patrimoine et à se voir un jour le restituer. Ceci devrait suffire à convaincre les États retardataires à ratifier au plus vite possible la Convention de 1995. La ratification d'un traité est souvent, en droit national, un chemin long et complexe, requérant la volonté d'hommes et de femmes déterminés, et je sais que vous l'êtes tous particulièrement. Dans le contexte international sombre que nous connaissons aujourd'hui, où le patrimoine culturel est devenu une cible privilégiée des criminels et des terroristes de tous ordres, ce chemin vaut la peine d'être emprunté. Il est même la voie juridique la plus sûre dont nous disposons actuellement, en particulier pour la mise en œuvre de la résolution 2199 du Conseil de sécurité des Nations Unies, adoptée dans le cadre du chapitre 7 de la Charte des Nations Unies le 12 février passé. Ce texte fait obligation aux États de prendre toutes les mesures nécessaires pour empêcher le commerce de biens culturels irakiens et syriens illégalement sortis d'Irak depuis le 6 août 1990 et de Syrie depuis le 15 mars 2011. Il demande à l'UNESCO, mais aussi aux autres organisations internationales compétentes, dont bien sûr l'UNIDROIT, d'accompagner les États dans la mise en œuvre de cette résolution. Ce n'est donc qu'au prix d'une ténacité sans faille que nous assurerons ensemble une protection efficace de notre héritage partagé. Nous en serons récompensés par la fierté de transmettre ce patrimoine intact aux générations qui nous suivront. J'en fais donc solennellement appel à vous, réunis à Rome aujourd'hui. Faites de la ratification de la Convention UNIDROIT votre cheval de bataille, enfourchez-les et portez les messages dans vos États respectifs. Il y va de l'intérêt de vos patrimoines, il va de la préservation de notre commune identité culturelle et de votre particulière identité culturelle. Et les États traditionnellement destinataires du trafic ne doivent pas demeurer sourds à cet appel. Je m'en voudrais de jouer les Cassandres en cette journée d'anniversaire, mais les exactions du terrorisme et du crime organisé menacent aujourd'hui le monde entier. Ne pensez pas que les vols et les pillages des collections nationales n'arrivent qu'aux autres. Les terribles destinées des musées européens soumis à l'occupation nazie pendant la Seconde Guerre mondiale nous rappellent actuellement qu'aucun État, si puissant pense l'être, ne peut se dire à l'abri. Dès lors, aucune arme, aucun bouclier ne doit être négligé. La Convention de 1995 est l'une de ces armes, elle est la réponse juridique au pillage. L'arsenal de protection légale du patrimoine contre le trafic offre également d'autres ressources que nous aurions tort de dédaigner. Je pense évidemment au Code de déontologie de l'ICOM pour les musées, mais aussi au Code international de déontologie pour les négociants en biens culturels rédigé par l'UNESCO. La lutte contre le trafic et pour les restitutions nécessite en effet l'implication de la communauté muséale internationale, mais aussi des acteurs du marché de l'art, et ce à tous les échelons. Je ne saurais trop leur recommander de se soumettre à ces différents codes, mais aussi d'appliquer spontanément, avant même la ratification par les États, la Convention de 1995 et notamment son article 4 définissant la diligence attendue de l'acquéreur d'un bien culturel, surtout quand il se trouve dans une position spéciale comme celle des musées ou des agents du marché de l'art. L'UNESCO, quant à elle, se tiendra toujours aux côtés de ses partenaires comme des États pour fédérer leur détermination et leur initiative. C'est ainsi que la directrice générale a inauguré en mars dernier à Bagdad la campagne United for Heritage afin de sensibiliser le monde aux enjeux de la protection du patrimoine culturel. C'est ainsi un accord que le 29 juin, à l'ouverture du Comité du patrimoine mondial à Bonn, sera lancé sous la même bannière Unis pour le patrimoine, une coalition internationale pour la protection du patrimoine culturel. C'est avec ces grands espoirs et ces projets plus grands encore que je vous laisse à présent. Je forme le souhait que cette journée de conférence, dont le programme s'annonce dense et riche, contribue à mieux faire connaître la Convention d'UNIDROIT de 1995 et à lui assurer le rayonnement qu'elle mérite pour une reconnaissance universelle et rapide que j'appelle de mes vœux en ce jour anniversaire. Je vous remercie.
Un grand merci à M. Pérez-Termignan. We have finished the first part of this conference. The speakers have introduced the subject. On behalf of UNIDROIT, I wish to extend to all of them a very warm thanks for their presentations. And we now start the second part. The first part, actually, this was the introduction, the first part of our conference. Thank you very much again.
Thank you.
Ladies and gentlemen, dear friends of cultural property, I'm talking about a different matter about private international law and why it is necessary to have international conventions to protect cultural property. My paper is in 3 parts. The first part to illustrate the problem. This Maori carving was the object of a famous British case, Attorney General of New Zealand versus Otis. A Maori tribesman found this carving in New Zealand. He got hold of it, and he became the owner of this carving. A foreign art dealer became known of this discovery, bought this painting for $6,000 and exported this carving to New York without export permission required under the New Zealand Historic Articles Act. In New York, he offered this carving to Mr. George Otis, a famous art collector in Geneva, and he sold these carvings to him for $65,000. Otis brought them to Geneva, and it became part of his collection. When Mr. Otis had to sell these carvings, he went to London and asked Sotheby's to sell it. Sotheby's made a nice catalog, and through this catalog, the government of New Zealand became known of this discovery. So they empowered the Attorney General of New Zealand to file an injunction so that this sale at auction could not take place. And he filed a suit against Otis, please return this carving because it has been illegally exported. The courts seized of this case said, well, let's try first whether this has been became the owner of New Zealand, whether New Zealand became the owner by forfeiture. But they went into the law of New Zealand and they found out that forfeiture is necessary to seize the object within New Zealand. And as this has not been done, so New Zealand did not become the owner of this object. And therefore, finally, the House of Lords, formerly the House of Lords, now Supreme Court, said, well, we are very, very sorry. You are not the owner, but we are sorry we cannot enforce foreign public law. The exports permit, this is public law, and we cannot enforce it in England. And therefore, we are very sorry, and its judgment was given for the defendant, for Mrs. Ortiz. And so this is a big case standing for this problem. You cannot enforce foreign public law in local courts. And the same was decided with this lady. Soon afterwards, this lady had been illegally exported from Spain, Marquesa de Santa Cruz. Judgment was given, Spain brought a lawsuit for the declaration that this has been illegally exported because they could not enforce foreign public law. Therefore, they sued for this declaration. They became it, and now it's in the Prado. You can see it. They bought it for $6 million. I think nowadays Malibu would pay $600 million. I do not know, because it's such a magnificent painting. And also this case decided very recently by the Court of Appeal, bound by this case of Attorney General of New Zealand. So therefore, the Court of Appeal had to distinguish this case and said, well, let's see whether Iran, this Iranian discovery, whether Iran became the owner of these artifacts. And they said, well, they have a patrimony law saying that all antiquities found within the Iran are state property. And so they said, well, this is state property, and so the Gallery of Barakat has to give it back to Iran. I come to my second part, where I have to discuss the problem. There are three basic principles in law. First, state authorities only can act within the state. Second, you do not enforce foreign public law in local courts. Third principle is whether in civil private law matters, foreign law can be taken into consideration. This is another problem. I do not want to discuss the first. This is a rule of public international law, and there's no doubt about it that you only can act within your own territory unless there are conventions. The second is also true, because also the case of Attorney General of New Zealand has been cited by other courts, not being courts of common law countries, also standing. The problem is, what do we do with this taken into account foreign public law in private law matters? I'm illustrating this by referring to a German case decided by the Federal Supreme Court in Karlsruhe. There were these masks of Benin. These were exported from Nigeria without expert permission. Of course, the smugglers sent them by sea, and there was an insurance contract for this voyage by sea to Hamburg. These masks got lost, and of course, the insured person asked the insurance company, we should get compensated. Of course, this insurance contract was governed by German law. And of course, the question arose whether you can insure illegally exported cultural objects in a local insurance contract. And so the highest court in Germany for civil and commercial matters said this, well, there must be an interest in an insurance contract. This is for everything. And here the interest is missing because he cannot insure illegally exported cultural objects. This is the famous Nigeria case. So they took account of this export prohibition of Nigeria with a simple local case. And therefore they said, well, you cannot be insured, therefore you do not get insurance money. The same was tried with this Swiss case of an Indian coin. I do not want to get into it, but the Swiss Federal Court in Lausanne declined to take account of the Indian cultural property legislation. And also this is an Austrian case where the Supreme Court of Austria declined to say, well, there is no breach of warranty simply because this artifact has been illegally exported from China. China didn't care about this, but the buyer said, well, I bought this, but I'm aware that this has been illegally exported and therefore declined to pay for it. Please give you back the money, you get back this artifact. This was declined. So now the third part, what's the conclusion? The conclusion is like this. With respect to illegally exported objects, where you have a direct act like the Attorney General of New Zealand or the Indian government, you cannot enforce foreign public law unless there is a convention. Of course, there are conventions. The UNESCO Convention of 1970, there is this UNIDROIT Convention. They provide for return of illegally exported cultural objects. Therefore, this is necessary. Let me once again come to the UNIDROIT Convention. In Chapter 2, there is something about stolen pieces of art. Even with stolen pieces of art, you run the problem with respect to a bona fide purchase. Of course, national legislators can change it. They could change their civil code. But in order to prevent this, because nobody does it, you see, therefore, in the Chapter 2 of the UNIDROIT Convention, it's written, even if you acquired bona fide by national law, you have to return it and get fair compensation for a bona fide purchaser. May I summarize? If local courts had to enforce foreign public law, international instruments are needed. This is a direct claim for enforcement of foreign public law, as the EU Directive of 1993, 2014, UNESCO Convention, or UNIDROIT Convention. But you have to be aware that only the directives of the European Union are only applicable within the European Union. Second, recovery may also be asked for by claiming back ownership of the country of origin. We saw it with the Barakat case. This was just a claim because the country of origin said, we are the owners, and they get it back. Whether foreign public law may be taken into consideration while applying governing law has to be decided in Europe now under Article 9, Rome I regulation. This is one of the most important and most complicated matters within the whole regulation. This article, however, is limited to overriding mandatory provisions in general, not about art law, of third countries, and limited to third countries where the obligation has to be performed. It's very limited and very restrictive. And whether this can also be applied in matters like this one, or this one, where this is not the country where the contract has to be performed, has to be decided by the European Court of Justice very soon, because nowadays a case is pending with the European Court of Justice, where the European Court of Justice has to decide whether also overriding mandatory provisions of third states in general may be taken into consideration. Finally, all these remedies do not exclude each other. This is explicitly provided by another famous Article 9 of the UNIDROIT Convention. And therefore, UNIDROIT Convention should be ratified. Thank you.
Let me thank Professor Sear. I was supposed to introduce him to you, but this was not done, first of all, because it was not needed, and then because we were behind schedule, and he felt that we should immediately start. So thank you again. I'm now giving the floor to Mr. Edouard Planche. Mr. Edouard Planche is a program specialist at UNESCO. He studied international public law and art history at the University of Aix-Marseille and at Exeter. And he will talk about the starting point, the 1970 UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property. Monsieur Planche, vous avez la parole.
Merci beaucoup. Merci beaucoup, Monsieur le Président. Ça n'est pas sans une certaine émotion et immense gratitude pour le personnel d'UNIDROIT, Monsieur le Secrétaire Général, Excellences, Mesdames, Messieurs, chère Marina, que je m'exprime aujourd'hui en souhaitant tout d'abord rendre un hommage particulier à Lindelprot, qui a été précurseur, juriste précurseur sur cette question de la protection des biens culturels, qui a été mon mentor à l'UNESCO et à qui nous devons beaucoup pour la promotion de ce thème au niveau international. Je vais me procéder à un petit historique de la Convention de 1970 et essayer de donner quelques informations sur le cheminement qui a conduit à l'adoption de la Convention d'UNIDROIT, puisqu'il faut remonter à 1960 pour que l'Assemblée générale des Nations unies adopte une déclaration sur l'octroi de l'indépendance aux pays et aux peuples coloniaux. Et c'est à partir des 1960 et des décennies qui ont suivi que de nombreux nouveaux États indépendants cherchent à récupérer leur patrimoine qui, pour beaucoup, était conservé dans les musées et les collections d'anciens pays colonisateurs. L'UNESCO se penche bien sûr sur cette question en vertu de son mandat et c'est en 1960 également que la Conférence générale de l'UNESCO adopte une résolution par laquelle elle demande à la Direction générale de préparer un rapport sur des mesures qu'il conviendrait de prendre pour interdire l'importation, l'exportation et la vente illicite de biens culturels. En 1964, l'UNESCO nomme un comité d'experts qui rédige des recommandations et ces recommandations conduisent à un texte qui est toujours en vigueur, qui est de nature juridique non contraignante mais toujours applicable, qui est la recommandation concernant les mesures à prendre pour interdire et empêcher l'exportation, l'importation et le transfert de propriété illicite des biens culturels. 4 ans plus tard, nous sommes alors en 1968, la Conférence générale de l'UNESCO décide de créer un comité qui va préparer un projet de convention. Ce projet est diffusé, comme le veut la pratique, auprès des États membres, des commentaires sont recueillis et nous arrivons en 1970 à l'adoption d'un texte qui est approuvé par le comité spécial d'experts gouvernementaux qui réunissait alors 61 États. Il faut noter qu'à cette époque, l'idée d'un texte à ce sujet n'a pas été accueillie avec beaucoup d'enthousiasme. Les États, notamment du marché de l'art ou de destination des biens culturels, ne voyaient pas d'un très bon œil ce texte qui traitait de la restitution des biens culturels. Il faut dire qu'aux négociations finales, la Suisse, par exemple, et le Royaume-Uni n'étaient pas représentés et que les États-Unis, finalement assez réticents au début, ont ratifié le texte en 1983. Mais d'autres grands marchés de l'art ont attendu encore plus longtemps avant d'apposer leur signature au bas du texte. La France l'a fait en 1997, le Japon et le Royaume-Uni en 2002, la Suisse en 2003, l'Allemagne en 2007, la Belgique et les Pays-Bas en 2009 seulement, et le dernier en date, le Luxembourg, qui vient de déposer son instrument de ratification en février, il y a donc 3 mois. Le Luxembourg est une place importante du marché de l'art, de nombreux collectionneurs s'y trouvent, c'est un pas important. L'Autriche est en train d'effectuer ce travail de ratification et quelques États européens manquent encore à l'appel pour, au moins dans l'Union européenne, arriver à une adhésion globale. Aujourd'hui, les déficits sont importants en Afrique de l'Est, dans la région Asie-Pacifique, comme vous pouvez le voir sur la carte, et en Afrique australe. Nous nous employons à ce que le texte devienne universel, mais les ratifications sont très lentes. Si l'on compare par exemple à la Convention du patrimoine mondial de 1972, qui a 191 États parties, un texte qui est quasiment universel, la Convention pour la sauvegarde du patrimoine culturel immatériel de 2003, qui a déjà été ratifiée par 162 pays, près d'un demi-siècle après, la Convention de 1970, elle, n'a recueilli que 128 États parties, si je puis dire. Il y a quelques explications à cela. D'abord, le sujet du trafic illicite n'est pas très populaire, il n'est pas très porteur, à la différence du thème du patrimoine mondial ou de la sauvegarde du patrimoine culturel immatériel. Le trafic illicite a une connotation péjorative qui n'est pas toujours vue d'un très bon œil par les États. D'autre part, le texte de 70 est le résultat d'un compromis entre des États et des positions, et ce compromis qui doit être transposé en droit national à travers des législations nationales que les États n'ont pas toujours adoptées ou pas toujours convenablement adoptées. Des obstacles de droit interne également se sont opposés à une bonne mise en œuvre de la Convention, des difficultés d'ordre constitutionnel, et pour toutes ces raisons, le secrétariat a eu et a toujours, je dois dire, beaucoup de difficultés à faire adopter ce texte dans des pays qui continuent à perdre leur patrimoine et qui, dans le même temps, réclament des restitutions de biens culturels. Alors la question est de savoir si, 40 ans après, il va encore falloir attendre plusieurs décennies pour que cette convention, qui est la pierre d'angle de la lutte contre le trafic illicite, devienne une norme universellement reconnue et appliquée. Pourtant, cette convention a plusieurs acquis que je vais brièvement passer en revue. Comme je vous l'ai dit, c'est le fruit d'un compromis, mais c'est un instrument de coopération internationale unique, instrument de coopération internationale entre les États et également entre des organisations intergouvernementales et non gouvernementales, au premier rang desquelles figure UNIDROIT. La Convention a exercé également une influence non négligeable sur l'opinion publique. Elle a entraîné un changement de mentalité, une évolution des attitudes professionnelles notamment, auprès des musées en tout premier lieu, aujourd'hui auprès du marché de l'art qui considère la Convention de l'UNESCO comme une norme tout à fait normale et qui doit être appliquée, y compris par les professionnels du marché. D'autre part, la Convention a conduit à l'adaptation d'un certain nombre de législations nationales. je me dois de citer le Convention on Cultural Property Implementation Act des États-Unis, mais également des lois qui ont changé au Japon, aux Pays-Bas, en Suisse. En 2005, nous fêtons les 10 ans de la loi d'application suisse au Royaume-Uni. La Convention a également été pionnière en matière de coopération internationale par son article 9, qui autorise les États dont le patrimoine est gravement menacé à faire appel aux autres États parties pour le protéger. La Syrie, bien entendu, et l'Irak font appel à cette base juridique pour que la coopération internationale se manifeste concrètement. En cinquième lieu, l'éducation du public, c'est un point fondamental de la Convention. Des ateliers sont organisés constamment, des activités de sensibilisation auxquelles participent évidemment UNIDROIT, Interpol, l'Organisation mondiale des douanes, le Bureau des Nations unies pour la lutte contre le crime organisé, l'Organisation mondiale des musées, le Conseil international des musées également. C'est un réseau de coopération unique qui est en place depuis des décennies et qui est très actif. Une autre réussite de la Convention est d'avoir suscité la rédaction d'autres conventions. La Convention du patrimoine sur la protection du patrimoine culturel subaquatique de 2001, le protocole à la Convention de La Haye de 1954 et bien sûr la Convention d'UNIDROIT auquel nous consacrons nos travaux aujourd'hui. Ces progrès qui sont liés à l'adoption de la Convention de 1970 ont fait évoluer les mécanismes visant à promouvoir la protection du patrimoine culturel mobilier, à travers notamment des groupes de pression nationaux qui se sont également mobilisés à nos côtés, notamment des groupes d'archéologues, d'anthropologues, qui ont fait pression pour que des législations et des pratiques professionnelles changent. Mais je dois également citer les attitudes des juristes, des conservateurs de musées et aujourd'hui, comme je vous le disais, des acteurs du marché de l'art qui ont compris qu'il fallait faire corps autour de la Convention de l'UNESCO. M. Pérez de Herminian a cité les codes d'éthique qui ont été élaborés à la suite de la Convention de 1970. Je ne reviens pas dessus. Il y a malgré tout des points faibles et ces points faibles ont trouvé une réponse à travers la Convention d'UNIDROIT de 1995. L'un des problèmes était celui de l'acquisition de bonne foi, de l'obligation de verser une indemnité équitable, des points qui ne sont pas détaillés, qui ne sont pas expliqués suffisamment dans la Convention de l'UNESCO. Ces questions ont été traitées par la Convention d'UNIDROIT de 1995. L'autre problème, celui de prouver l'existence d'un lien légal avec le bien réclamé dans un autre pays, et la difficulté particulière que pose le retour des biens archéologiques qui ont été fouillés illégalement, c'est-à-dire lorsque l'État d'origine de ces biens n'en connaît même pas l'existence, puisqu'ils sont le fruit de pillages ou de vols. Une fois de plus, UNIDROIT, UNESCO ont joint leurs forces, ont travaillé ensemble et ont élaboré des modèles de disposition avec un groupe d'experts. Je crois que vous en avez reçu une copie. C'est un outil juridique qui est à la disposition des États parce que l'un des points clés pour la lutte contre le trafic illicite est que les législations nationales soient adaptées et que la propriété de l'État sur les biens culturels soit clairement définie, notamment la propriété sur les biens archéologiques non découverts. L'autre question sensible est celle de la rétroactivité. Évidemment, la Convention n'est pas rétroactive, mais rien n'interdit, tout comme pour la Convention d'UNIDROIT, que les principes soient appliqués à des situations antérieures. Et même si les conventions ne sont pas toujours à l'origine stricto sensu des restitutions, leurs principes ont servi à ce que des mécanismes de restitution soient mis en place. Alors le cheminement vers UNIDROIT remonte à 1982, puisque dès cette date, on s'est aperçu des faiblesses, des insuffisances de la Convention de l'UNESCO. Et il a donc été recommandé à l'UNESCO de travailler et d'entreprendre une coopération avec une organisation internationale spécialisée en droit international privé, domaine dans lequel l'UNESCO n'a pas compétence. C'est ainsi que les professeurs Châtelain et Rodota, que je me dois de citer, ont préconisé notamment le réexamen du principe de l'acquéreur de bonne foi, le principe de la diligence requise, et UNESCO a chargé UNIDROIT de cette tâche. En 1983, consciente que la Convention de 70 avait besoin d'être complétée, l'UNESCO crée un comité d'experts pour examiner les critiques qui étaient formulées à l'encontre de son texte, notamment le faible taux de ratification et les interrogations sur le pillage des sites archéologiques, comme je viens de vous le dire. C'est ainsi que la coopération avec UNIDROIT prend naissance et que des efforts sont entrepris pour améliorer les fondements juridiques internationaux du retour des biens culturels. Et cela a conduit à l'adoption de la Convention d'UNIDROIT sur les biens culturels volés ou illicitement exportés en 1995, ici même. Il s'agit d'un moment décisif dans l'harmonisation des lois nationales sur l'acquisition et le retour. À l'instar de la Convention d'UNIDROIT, la Convention de 1970 était le résultat d'un compromis qui est accepté. Et il faut souligner qu'il serait inopportun de revenir sur ce compromis qui a été négocié pendant des années. UNIDROIT est également le fruit d'un compromis qui a été difficile, mais qui est un compromis acceptable, puisqu'il a été ratifié par des États qui ont participé aux négociations et qui représentaient à l'époque plusieurs intérêts divergents. Il faut souligner l'implication de la France au moment de la négociation du texte, pays source mais également pays du marché de l'art, et l'appel est lancé pour qu'un pays important tel que la France, qui a été clé dans la rédaction du texte d'UNIDROIT, franchisse le pas et ratifie la Convention. Tandis que UNIDROIT compte aujourd'hui 37 États parties, il serait illusoire de vouloir penser à un nouveau protocole ou à une nouvelle convention. Ça serait même catastrophique. Catastrophique de vouloir adopter soit une norme moins stricte, puisque certains États considèrent qu'UNIDROIT va trop loin dans le processus, dans les dispositions relatives à la restitution des biens culturels, alors que d'autres États considèrent qu'UNIDROIT ne va pas assez loin, n'est pas assez restrictive, notamment concernant la restitution des biens archéologiques. UNIDROIT est le texte qui a certainement été révolutionnaire en son temps, peut-être trop avancé en 1995, mais qui aujourd'hui est la réponse juridique nécessaire face au pillage à grande échelle et aux destructions auxquelles malheureusement nous assistons. J'en termine donc pour dire que l'UNIDROIT est la réponse juridique la plus appropriée, la plus opérationnelle aujourd'hui face à la situation que nous connaissons. M. Pérez de Arminian a dit qu'il s'agit du bras opérationnel de la Convention de l'UNESCO. Probablement trop audacieuse, trop révolutionnaire en 1995, elle est aujourd'hui pleinement à maturité et l'urgence patrimoniale et sécuritaire générée par les destructions et pillages en cours aujourd'hui, sans parler des pillages qui démarrent au Népal, puisque les catastrophes naturelles entraînent également des actes de malveillance et que le patrimoine au Népal est aujourd'hui menacé, eh bien, il n'y a plus de place pour la tergiversation et les États dits de destination, comme les États sources, doivent aujourd'hui ratifier UNIDROIT et en faire un instrument universel. La résolution du Conseil de sécurité des Nations Unies de février est là pour nous le rappeler. Les engagements que les États doivent prendre doivent être concrets et immédiats. Sans cela, nous ne parviendrons pas à endiguer une situation de destruction du patrimoine qui est aujourd'hui catastrophique. Je vous remercie beaucoup de votre attention.
Un grand merci à M. Planche. I'm now giving the floor to the next speaker, President Francesco Rutelli. He needs no presentation, particularly here in Italy, but I will simply remind you that he was the mayor of Rome at the time when the convention was adopted, and he's been Minister of Culture and Tourism and has done a lot for the protection of cultural property. So I'm very particularly glad to give him the floor. President Rutelli, you have the floor.
Thank you, Mr. Chairman. Thank you all. We are very proud to have this meeting in Rome today. I want to thank UNIDROIT. I want to thank you for your work, your passionate work. Ms. Schneider just left this table, but she always gives her and your passion to such an important cause. Yes, I was the mayor of Rome during the proceedings and the approbation of the convention here in Rome. Maybe there is a spirit of Rome allowing the European Union here in the Capitole Hill to adopt the treaties of Rome in 1957 maybe there was also a spirit of Rome and of Capitole Hill. In '98, when the statute of the International Criminal Court was also approved here. But of course, now we are confronted with very tough challenges. And I think my goal should be, and I will try to say a few words about, I've been asked to talk about Italian policies for the restitution of illicitly trafficked cultural heritage based on the rule of law and international cooperation. I think that these two concepts work together or don't work at all. We need to tackle, to fight illicit trafficking, and we need cooperation. And I think that the Italian experience, also during the experience of many ministers of culture in our government, was really inspired by that two goals. I was responsible for some relevant restitutions to our national heritage in the years between 2006 and 2008, when I was Minister of Culture. But it never was a nationalistic issue. Absolutely. It was a cooperation issue. And it was a way of fighting crime against art and cultural heritage, starting from my country. It was not only an attempt to achieve a big change by big institutions, private museums, public museums, but it was also, from our side, the goal to stop illegal cooperation, local mafias, local traffickers, what we call tombaroli, acting in our country. So I think that these are common goals and not nationalistic goals. I'd like to give you a few examples. If you go around Rome and you look at the obelisk, of course it's a stolen artifact. Even if it's a rebaptized artifact. Because when the Pope Sixtus V decided to put a cross over the obelisk the Roman Empire collected from Egypt, he decided to give a new semantic, a new meaning. It was very important also as a signal to people walking in Rome, because these obelisks were erected in front of great churches in order to show where to go at the end of the roads built by the Renaissance popes. But you will not see anymore the Axum obelisk in Rome, because our government gave it back to Ethiopia. It was a legacy of colonial Italian policy during the fascism. It was a controversial decision, but at the very end, our country decided to give back what belonged to another country, and that was the fruit of a recent historical colonial experience. I don't want to be ideological from this side, because last year I visited in Yale the astonishing museum regarding Dura Europos, the astonishing part of the Yale Museum regarding Dura Europos. And at the same time, I see that Italy made an important and also controversial restitution to Libya from the National Archaeological Museum, the Venus of Cyrene. It was an appropriate decision. But of course, we are very worried of what is happening today to the Venus of Cyrene. That's the reason why if I go today to the Dura Europos section in the Yale Museum, I think that the agreement, the legal agreement that allowed to the American archaeologists to bring there such an astonishing collection from Syria, maybe was a blessing if we are looking today at what is happening in Syria and in Dura Europos. So I think we have to have a political point of view while we know that we are discussing about political issues, and of course UNIDROIT action is so important because it is the other part of the issue, the private issue. And so if cooperation without real fight for legality, international legality, is impossible, fighting illicit trafficking in archaeology and art is impossible if we don't reach a satisfactory agreement through the UNIDROIT, in the UNIDROIT framework regarding the private sector. And it is exactly what is happening today in Iraq and Syria, in the area ruled today by ISIL, Daesh. It's a very important issue because, of course, international public opinion is impressed, is moved by the distractions we're going to see everywhere. I know the fear Professor Paolo Mattia, everybody of yours know very well, his outstanding job in EBLA, his work in EBLA for decades. Everybody who worked in this real cradle of humankind, of cultural humankind, are so worried of what is happening. Decades of work, decades of international cooperation, risk to go in nothing. But we know that there are two. It's a twofold tragedy. The first one is ideological iconoclasm, an ideological distraction that is underway. But there is a more hidden reality, that is illicit trafficking, because you see big statues destroyed, sometimes copies, luckily, but not rarely irreplaceable masterpieces, but you don't see small objects. You don't see this trafficking action. You don't see how much these fundamentalistic subjects are self-financing their action through selling these artifacts to illegal markets. There is somebody who's selling that, there is somebody who's purchasing, who's buying that. And there is a completely insufficient action, notwithstanding the excellent initiatives of UNESCO, the very important recent decision Mr. Perez de Armenian and Mr. Planche declared about the UN Security Council asking the international community to act in a tougher way. But of course, we know that we need a stronger action and a more efficient opportunity to achieve concrete results. Of course, official policies are very important. I look to Mr. Perez Darminian and I think to a miracle, maybe somehow sidelined for understandable reason in the recent Spanish history, with the Civil War silent agreement between the two sides in order to save your beloved and beloved by all the humankind heritage in El Prado, Escorial, allowing during the Civil War to these masterpieces to leave Madrid, to reach United Nations and Switzerland, then to come back. Both sides fighting furiously, decide to stop this fight in order to save a common heritage. I think it is an extraordinary page of civilization, even in such a dramatic historical moment. So I think we have to know here in Campidoglio that maybe here somehow started a modern vision of European culture and Western culture that became through international conventions under the UNESCO auspices universal. When Quatremer de Quincy, an intellectual, a French intellectual, end of 18th century, wrote his celebrated letters to Miranda, asking not to spoil, not to steal, and not to bring to France, to Louvre, about to be the great institution of French success, political and military success in terms of cultural hegemony. He wrote, excuse me if I read it in French, ce sera comme membre d'une république générale des arts et des sciences, et non habitant de telle ou telle nation, que je discuterai de cet intérêt que toutes les parties ont à la conservation du tout. Quel est-il cet intérêt? C'est celui de la civilisation, du perfectionnement des moyens de bonheur et de plaisir, de l'avancement et des progrès, de l'instruction et de la raison, de l'amélioration enfin de l'espèce humaine. Et ça était son appel à laisser à Rome, en Italie, le patrimoine qui était italien, mais qui était de cette république des arts et de la culture qu'il imaginait. C'est vraiment la naissance de l'Europe, de la culture moderne, dans les mots d'une très petite minorité culturelle qui lançait cette idée. Alors, je vais conclure et je voudrais souligner en particulier ça. Le gouvernement italien aujourd'hui est en train de proposer ce qu'on a appelé Cultural Heritage Helmets. On connaît parfaitement l'énorme difficulté de créer, je regarde le professeur De Caro, je regarde son prédécesseur, professeur Bushnaki, on sait parfaitement que quand il y a une guerre, c'est très difficile de sauver les vies humaines et il semble impossible de sauver les patrimoines. Mais sans doute, un homme comme Quatremer de Quincy aujourd'hui irait dire la même chose. Il faut risquer quelque chose de plus pour empêcher que des patrimoines irremplaçables soient détruits. Il faut que la communauté internationale décide que c'est inacceptable, que ce qu'il est en train d'arriver dans les zones contrôlées par ISIL puisse continuer. Naturellement, il faut la coopération de deux parties, mais il faut aussi une action de la communauté internationale qui soit plus forte, plus décisive et qui est aussi une composante éthique. Je comprends que ça peut sembler absurde, parce que l'éthique ne commande pas les marchés, parce que l'éthique ne commande pas les guerres. Mais nous avons eu des expériences très importantes, aussi avec des collectionneurs privés qui ont décidé de rendre au patrimoine italien du patrimoine qu'ils avaient acheté, je dirais légalement, ne sachant pas qu'il s'agissait de matériel archéologique volé. Ça est très important. Et ça, c'est vérifié exclusivement pour une raison éthique. Parce que il disait, je ne veux pas garder des objets sanglants dans ma maison. Je vais confier au progrès de la culture une idée qui soit une idée de responsabilité commune. C'est mon plaisir, c'est ma culture, c'est ma formation, c'est ce que j'ai pu acheter, mais je ne peux pas accepter que ça arrive dans un contexte qui est un contexte de spoliation et de violence. Alors j'imagine que cette dimension éthique devrait être encore une fois amenée aux Nations Unies, ou amenée à la communauté internationale, et que l'initiative italienne de ces années essayait de tenir ensemble la lutte contre l'action illégale contre le patrimoine et la coopération institutionnelle, c'est-à-dire quand un musée nous a rendu des chefs-d'œuvre, les gouvernements italiens ont donné à ces musées des prêts, long terme prêts, avec des chefs-d'œuvre encore plus importants. Il n'y avait pas de lieux vides dans ces musées. C'était le plein de la culture, de la légalité et aussi de la fruition ouverte et relevante. Nous, Européens, nous avons un grand débat avec l'euro. Mais si vous allez regarder dans la, je ne sais pas comment ça s'appelle, la filigrane, watermark, filigrane, de la banconota de 5 €, vous allez voir une très belle Europa qui se trouve au Louvre. Mais elle vient de Taranto. L'Italie ni M. Draghi, qui a signé cette note, ne vont pas demander que ces vases, cette peinture aille revenir en Italie. Non, c'est le patrimoine de l'humanité et puis c'est l'histoire. On ne va pas demander, après qu'on a obtenu qu'ici, dans les musées, plusieurs d'œuvres, et dans le Capitole, plusieurs d'œuvres provenant aussi des volées pendant la campagne militaire par Napoléon, conquis par Napoléon, sont revenus. Ça, c'est l'histoire, c'est fini. On a des périodes historiques qui sont l'histoire. Aujourd'hui, l'histoire, il faut la faire en empêchant que la destruction continue et que la légalité soit défaite. Il faut plus de coopération, plus de légalité et j'espère que l'action de UNIDROIT soit renforcée par tous les États membres et ceux qui n'ont pas encore ratifié cette convention. Merci beaucoup.
Really, many thanks to President Rutelli for thoughtful political insights and for the passion that he shows still in fostering the cause of the protection of culture and the protection of art. We are a bit behind schedule, but we will not impose upon the next speaker, Professor Kouroupas, to shorten her speech. I suggest that we will shorten rather the pause that will follow thereafter. Professor Kouroupas, you have the floor.
Perhaps I will speed up my speech. I wish to thank you, Mr. Professor Mazzoni, and to thank especially the Director General of UNESCO, Angelo Faria, and Senior Legal Expert Marina Schneider, and express deep gratitude to them for their staunch, unrelenting efforts in promoting the 1995 UNIDROIT Convention. It's a pleasure to participate in this milestone observance of the adoption of the 1995 UNIDROIT Convention. It was my privilege at the time to be part of the United States delegation that participated in the negotiation of the convention, leading to its adoption in June 1995. Although the United States contributed substantially to those negotiations and signed the final document, it has yet to ratify it. However, the United States closely follows developments related to the 1995 Convention and attaches great value to its application among its states parties. Since 1983, the United States has been actively implementing the 1970 UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property, and is a leader in the global effort to stem the looting and trafficking of cultural objects. The President of the United States considers this a foreign policy priority, as does the Secretary of State and other senior officials in the department, the Undersecretary for Public Diplomacy, and the Assistant Secretary of State for Educational and Cultural Affairs. As we know, UNIDROIT and UNESCO conventions on cultural property were adopted in response to worldwide concern for theft and wanton pillage in countries rich in archaeological resources and the appearance in market countries such as the U.S. of large quantities of objects of unknown provenance. This observance today comes at a time, as we've already noted, of heightened international concern that cultural property looting and trafficking is in the grip of transnational organized crime and extremists in the Middle East and Central Asia. As never before, we are challenged to engage to the fullest extent the international framework of cooperation that these two complementary conventions represent. Today, I hope to provide you some insight into how the United States is implementing obligations, particularly those that it has under the 1970 Convention, as well as other laws at its disposal. Because the 1970 Convention was not self-executing in the United States, it was necessary for our Congress to pass implementing legislation. And it is the Convention on Cultural Property Implementation Act. In conjunction with that statute, the U.S. Senate issued a report that concluded that the demand for cultural artifacts has resulted in the irremediable destruction of archaeological sites and articles of cultural property, depriving other countries of their cultural patrimony and the world of important knowledge of its past. But that Senate report also weighed the following consideration, and that is that the interest of the United States in the Convention extends beyond our import market and our interest in fostering the careful study of foreign cultures. The increasing interest in Native American, Hawaiian, and Alaskan artifacts has spurred the pillaging of U.S. historic sites, and their destruction and the disappearance of that historic record has given rise to a profound national interest in joining other countries to control the trafficking of such articles in international commerce. And it is this concern about the jeopardy to indigenous American heritage that was among the factors motivating the United States to play an active role in the development many years later of the 1995 Convention. Returning to the 1970 Convention, the U.S. enabling legislation implements two principal articles of 1970. One is Article 7B1, which calls upon a state party to prohibit the import of cultural property stolen from a museum or a religious or secular public monument or similar institution, provided that such property is documented as appertaining to the inventory of that institution. The provision in U.S. law that implements Article 7B1 does precisely that. It provides for a standing U.S. import restriction on documented material stolen from such institutions in any state party to the convention. But Article 9, which is the other principal article that U.S. legislation implements, and is the core of U.S. implementation of the convention, refers to the pillage of objects not yet documented and is the most central element of U.S. implementation to the convention. Any state party to this convention whose cultural patrimony is in jeopardy from pillage of archaeological or ethnological materials may call upon other states who are affected. The states parties to this convention undertake to participate in a concerted international effort to determine and to carry out the necessary concrete measures, including the control of exports and imports. The United States deems Article 9 to be the portal through which another state party may call upon the United States for import restrictions on archaeological and ethnological material that remains today in its country of origin. This material, particularly archaeological objects in situ, which cannot be properly documented without scientific excavation, is the most vulnerable to pillage and illicit movement across international borders. Most countries restrict the export of their cultural property, explicitly restrict it, but such export controls, foreign export controls, are not enforceable in the United States without specific U.S. import restrictions. It is only through its implementing legislation that the United States has the authority to impose such import restrictions, and only if a state party requests them by invoking Article 9 of the Convention. A number of states have done that, including Italy, and we're very proud of the bilateral agreement that we have with Italy ongoing. When a state party requests U.S. import restrictions, that request must inform the United States about certain degrees of action that have been taken and certain conditions that exist. First and foremost, that the cultural patrimony of the state party is in jeopardy from the pillage of archaeological and ethnological material, that it has taken measures consistent with the 1970 Convention to protect its patrimony. And it is in the context of assessing what steps a state party has taken to protect its cultural patrimony that the United States places great value on whether that country has adopted the 1995 UNIDROIT Convention. Because for us, this demonstrates the extent to which a country has reached to shore up available legal avenues. Another criterion we have is that the import restrictions would be a substantial benefit, and in this context, we consider what other states have done to regulate the illicit importation of cultural property. And again, we consider whether other states have adopted the 1995 Convention as we assess this particular statutory requirement we have. And finally, that the U.S. import restrictions would be consistent with the general interest of the international community in the interchange of cultural property among nations for scientific, cultural, and educational purposes. And we place great emphasis on this, and again, pointing to our agreement with Italy. Italy and the United States, and our museums and Italian museums have engaged quite abundantly in the last several years on cultural exchanges, scientific research as well. Upon receiving an Article 9 request from a foreign government, the President can exercise his decision-making and negotiating authorities to impose import restrictions by entering into an agreement with that country. These authorities are delegated to the Department of State. But to inform the decision-making process, a statutory cultural property advisory committee exists, and it's convened by the department to review those statutory criteria I just mentioned and to submit its findings and recommendations. Should a favorable decision by the President be made, it leads to an agreement, as with Italy, to restrict certain categories of objects vulnerable to pillage. However, an agreement sets forth certain goals to be accomplished during the effective period of that agreement, and those goals are contained within a special article, which we refer to as Article 2. But pertaining to the restriction itself, it comes in the form, it can only come once an agreement is signed, and it comes in the form of a designated list that is published in our Federal Register by the Department of Homeland Security, which is where Customs and Border Protection resides. And they are the ones who have the law enforcement responsibility under our statute. Objects that are restricted categories that represent restricted categories actually are permitted to enter the U.S., provided there's an export certificate issued by the country of origin or other evidence that demonstrates that material has been in circulation much earlier than the import restriction itself. But a very important aspect of U.S. import restrictions under the 1970 Convention is this, and that is that should archaeological or ethnological material be found at the port of entry entering unlawfully, the burden of proof rests with the importer, not the country of origin. And this is a very beneficial aspect of our implementing legislation. Other laws that the U.S. has in its arsenal, in addition to implementing the 1970, and I want to clarify that our import restrictions are not, do not recognize another country's export law. Do recognize another country's export law, not another country's ownership law. And I want to make that distinction. A violation of such an import restriction is a civil violation, and there are other customs statutes that address outright smuggling and fraud that may also be enforced in the recovery of cultural property in the United States, and often these violations result in fines and prison sentences. The gold fiale that was recovered and returned to Italy several years ago was one of those objects that entered the United States under an accusation of fraud. It was misstated as country of origin being Switzerland, not Italy, and also there was a false valuation attached to that. So some years later, our customs agents were able to recover that piece and return it to Italy. And I think it's coming back for, or has been back for exhibition under legal circumstances. But there is another very important U.S. criminal statute that has been applied successfully to the recovery of undocumented cultural property stolen from its country of origin, provided that a country has a strong national law of ownership and can prove the objects belong to that country. Under the U.S. National Stolen Property Act, the United States has long recognized that national patrimony laws vesting ownership in the state of all cultural property, known and unknown, can be helpful in the recovery of undocumented cultural objects. The underlying legal principle is that a thief who knowingly transports such items in interstate or foreign commerce cannot transfer good title to stolen property, be it an automobile or cultural property. Even though the burden of proof in such cases rests with the country of origin, there is important case law in the United States that has favored foreign government claimants. One example is the United States versus Schultz, and in this case, not only did the courts affirm Egypt's patrimony law, which declared all antiquities after 1983 to be the property of the Egyptian government, but it rejected the defendant's claim of ignorance that he violated the National Stolen Property Act. The courts upheld the principle that ignorance of the law generally is no defense to a criminal charge. The facts of this case can be said to have some relevance to certain provisions of the 1995 UNIDROIT Convention concerning national ownership of cultural property and due diligence on the part of the trade and collecting communities. The court in this instance also recognized that Egypt had a responsibility for due diligence in the proactive application of its national law of ownership. In conclusion, there are often questions, are your steps to implement the convention working? How do you measure success? How do you go forward in furthering your efforts? And I will say that it's difficult to measure success. And I would quote the late Paul Bator, a American legal scholar, now deceased, who said that no detailed data exist that provide reliable insights into either the precise nature or magnitude of trade in cultural property. Much about the art trade simply is not knowable because, he said, of the vast number of undiscovered and unidentified objects and the secret nature of much of the trade. But we in the United States, and the State Department in particular, we conduct workshops for U.S. Customs agents, for investigators, as well as other agents. They are regularly trained in matters concerning the trafficking of cultural property, and with the help of experts are able to identify antiquities and other cultural property entering our border. And at the beginning of these series of workshops that we've been holding under the sponsorship of the State Department, and I must say at the request of U.S. Congress, in 2004, U.S. Customs opened 4 cultural property cases. In 2014, 300 cases were opened. In recent years, more than 2,600 objects have been repatriated and more are on the way. What is very important to the United States, however, in addition to its law enforcement mechanisms, are, in particular with respect to the bilateral agreements we have within our implementing framework for the 1970 Convention, Article 2 of each agreement sets forth long-term goals intended to benefit cultural patrimony through increased public awareness, museum development, documentation and inventory of collections and sites, technical training and conservation and site security, professional development, research, and exchanges for cultural, educational, and scientific purposes. On the one hand, import restrictions are intended to reduce the incentive for further pillage. On the other, provisions in our agreements under Article 2 open the way for improved and sustained strategies for protecting a cultural's national patrimony and in making such patrimony accessible for study and educational and cultural exchange. And Italy has been very prominent and a very generous partner in this regard. And this very museum, the Capitole Hill Museum, recently loaned a couple of its iconic possessions, the Capitole Hill Venus and the Dying Gaul, were loaned to the National Gallery of Art in Washington, D.C. in recent years. There are many, many other examples of Italian generosity as we work with Italy to protect and reduce the illicit looting and trafficking. We also work to open up those more legal and more acceptable avenues of exchange for this material. So these bilateral agreements set forth import restrictions of course, but also identify the strategies that went through just a moment ago for safeguarding cultural heritage and raising public awareness. And in this way, the U.S. implementing legislation is not only an instrument for stabilizing situations of pillage, but also an agent for advancing the steps necessary to secure the foundations of sustainable heritage stewardship. Thank you very much.
Thank you very much for the presentation of Mrs. Kouroupas. As a moderator, I take responsibility for mistakes and omissions and the fact that we are behind schedule, but I wanted the panelists here to receive your applause because they've given excellent presentations and we're really happy about the result of this panel. Thank you very much.